Hi, we are from TLBA. In this video, we are going to cover on the topic of ethics in publicizing the profession. Firstly, on the point of advertisement and publication,
The first statute is Legal Profession, Practice and Etiquette Rules 1978. Rule 48 provides that lawyers are not allowed to publish his or her own photograph as a member of Bar Council in the press or any periodicals unless consented by the Attorney General. Next, the second statute providing for advertisement and publication is Legal Profession, Publicity Rules 2001. Rule 2 defines publicize as means to make known to the public through any form of advertisement. Rule 3, on the other hand, stated that these rules apply to every advocate and solicitor, whether he is practicing as a sole proprietor or as a partner, an employee or a consultant of a firm. Rule 4 of the same rules provides that legal practitioners cannot publicize their practice or practice firm except in accordance with the rules. In addition, Rule 8 stated that an advocate and solicitor may publicize his practice or the practice of his firm by inserting an advertisement with approved information only, which is befitting the dignity of the legal profession in such media permitted by these rules. Furthermore, the record of the advertisement shall be kept at the principal place of business for a period of at least 12 months from the date of its publication. The record shall be produced for inspection upon request by the Bar Council. Rule 13 allows an advocate and solicitor to publish journals, magazines, newsletters where the published materials may only be displayed at the firm. Meanwhile, Rule 15 stated that the legal practitioners can only mention the approved information while having interviews with press, radio and television. And lastly, Rule 21 provides that the act of publicity via electronic media can only be done by the legal practitioner by putting in only the approved information in a manner determined by the Bar Council. These rules basically allows only approved information to be publicized to the public for the purpose of publication of any material.
Principles in advertisement and publication. Legal practitioners are only allowed to publicize the 18 specified approved information in any publication which in turn is of limited circulation. The legal firm are bound to adhere strictly to its governing law and regulation, namely the LPA 1976, Legal Profession Practice and Ethics Rule 1978 and LP Publicity Rule 2001. In essence, legal practitioners are not allowed to publicize to the public at large. This law have restricted advertisement and publication in legal service, particularly in the use of electronic media such as television and radio. It is the duty of every advocate and solicitor to uphold the dignity and high standing of the profession and his own dignity as a member of it.
For advertisement and publication, this can best seen in the case of Majlis Peguam against Datuk Sri Dr. Muhammad Syafiq Abdullah. In this case, on September 2010, the Bar Councils wrote to the disciplinary board complaining that the respondent appears to have breached the Legal Profession Publicity Rules 2001, which the complaint was based on interview given by the respondent that appeared in 2 articles in the Star newspaper. In that article, the article referred to the respondent as a high-profile lawyer and a top lawyer. The article further stated that people had no difficulty finding the respondent's office, which has no signboard because of respondent reputation. However, in this case, the respondent had been alleged to publicize himself and his firm in interview by the Star newspaper. The court held that the respondent had not publicized himself or his firm in a manner that infringed Rule 5 of Legal Profession Publicity Rule 2001. The words describing the respondent as high-profile lawyer and top lawyer were the journalist's own remark and personal opinion. The statements were made in response to questions relating to the criminal justice system and his preference insofar as work was concerned. This was something which the respondent could not have prevented the journalist from expressing, although the respondent had control over what he was saying during the interview with the journalist. but he had no control over the information provided by him, which in turn led to the journalist making such perceived laudatory remarks.
Prohibition on touting. What is the meaning of touting? According to Cambridge Dictionary, touting is defined as to advertise, talk about, or praise something or someone repeatedly, especially as a way of encouraging people to like, accept, or buy something. So basically, touts are persons who receive commissions from law firm in return for securing clients by way of advertising, encouraging, praising the law firms. Touts typically approach members of the public who are laymen and innocent, who in need of legal representation, and apply pressure on them to engage the law firm that the touts represent. Rule 51 and 52 of LPA prohibits lawyers from participating in touting. This means that no lawyers can directly advertise to clients and cannot be third party who can act as an advocate and solicitor to bring clients to these lawyers. This prohibition is to prevent against nuisance in this legal field. Lawyers who are involved in touting are committing misconduct under Section 94 Clause 3, Paragraph F, G, H of LPA. This misconduct is against by Bar Council. In fact, Bar Council has taken an action against alleged online touting. For the cases on prohibition of touting, we can see in the case of Bar Malaysia and Index Continent Sdn Berhad 2016, where in this case, the High Court granted an ad interim injunction restraining the respondent from continuing to advertise, promote, or otherwise communicate its purported provision of prepaid legal service from carrying or engaging in the provision for the impugned services to members of the public, and from directly or indirectly soliciting clients, members or subscribers for its answers in law scheme in breach of Section 37 of the Legal Professional Act 1976. This case was appealed until Federal Court on the issue whether Bar Council has local standing to sue Index Continent, and Federal Court allowed the appeal and remitted to the High Court for trial. Also, in the case of a solicitor 1955, where Scott L.J. said, touting for clients is like advertising, fundamentally inconsistent with the interests of the public and with the honor of the profession. This function of a solicitor is to advise or negotiate or fight for a client, but only if retained, the client must seek him, but he must not seek the client. For the conclusion, touts exist because lawyers use them. Preying on the vulnerable and helpless outside the court through touting is something that every lawyer must avoid. Touting will only end when members of the legal profession cease this unbecoming conduct.
I will proceed to regulations regarding letterheads, nameplate, stationery, name cards, brochure, leaflets and pamphlets. Firstly, it is provided under Legal Profession Publicity Rules 2001 that all materials used for the purpose of publicizing lawyering business, such as letterhead, stationery, nameplate, business card, and so on, which are to be used by an advocate and solicitor for professional purposes, that should only contain approved information. Rule 7 provides for letterhead and stationery, while Rule 9 discusses the nameplate. It is provided under Rule 9 that nameplate must be displayed outside of the firm's premises, and the size cannot be larger than 92 centimeters by 61 centimeters. Furthermore, as stated under Rule 11, business card can only be distributed discreetly by the advocate and solicitor or his employees on occasions where it is proper for the advocate and solicitor to expose his professional identity. Anyone who is non-employee should not be allowed to distribute the business cards on the advocate and solicitor behalf.
Rule 12 later provides that brochures, leaflets and pamphlets produced by the advocate and solicitor can be distributed discreetly in professional manner to certain group of people such as his employees, other advocate and solicitor who is practicing in his law firm, his clients, anyone inquiring services provided by his firm, or anyone he has professional dealings with. Lastly, it must be noted that the flyers cannot be displayed outside of the firm's premises, and the copies of it must be kept for at least 12 months after being published, and if requested, being produced the copy of it to Bar Council for inspection.
On the point of free legal advice,
Lawyers can also publicize their profession through free legal advice. Based on Rule 22 of Legal Profession Publicity Rules 2001, it states that a lawyer can give free legal advice to a person at a legal aid clinic with the purpose of providing legal assistance to the public. However, there are certain things that the lawyer is not permitted to do. Firstly, he cannot disclose his firm's name. Secondly, he cannot distribute any of his business cards or any brochure, leaflet, pamphlet, and so on relating to his or his firm's practice. And third, he cannot act for the advised person, where the person that he gives such advice.
Under the Act of Legal Profession Publicity Rules 2001, based on Rule 22 subsection 2, it is stated that a lawyer can give free legal advice to the public or any section of it by writing an article or letter for publication in any publication. However, he cannot permit any of his or his firm's information, except his name and that he is a lawyer, to be stated in the article or letter, or to be published in the publication where the article or letter is published.
In Section 29, Subsection 1 of Legal Aid Act 1971, it states that all persons resident and present in Malaysia shall get legal advice on criminal proceeding, civil proceeding, and all other matters.
that's all from us. Thank you.